much.
Welcome. Action.
So my court case is Atkins versus Virginia, and it pertains to whether or not the execution of a mentally retarded person is considered cruel. So the question asked was, is the execution of mentally retarded persons cruel and unusual punishment, and is it prohibited by the Eighth Amendment? Some important dates. The case was argued on February 20th, 2002, and it was decided on June 20th, 2002. So it took them about 4 months to come up with a final verdict. The advocates for the case were the petitioner, James W. Ellis, and he argued for Atkins, and the respondent was Pamela A. Rumps, and she argued for the state of Virginia. So, some background information. This is Daryl Renard Atkins, and he was sentenced to death for shooting the patron of an automated teller machine, and he was later found guilty of abduction, armed robbery, and capital murder. The case occurred in 1996, so he was 18 years old, and he did not work alone. He was influenced by his accomplice, William Jones, and the two of them were intoxicated the day of the crime after having been drinking and smoking. They abducted Airman Eric Nesbitt, and they took him to a nearby ATM where they forced him to withdraw $200 from his account. And Nesbitt was later found in an isolated location, dead after having been shot 8 times. However, the ATM camera did take a video of Atkins and Jones, so they were caught, and they were both charged with capital murder. But in court, Atkins' side of the story was super inconsistent. So they offered Jones a plea bargain in return for full testimony against Atkins. During the trial, there was one witness, a forensic psychologist, and he testified that Atkins was in fact mentally retarded, and he got that from his interviews, school records, court records, and Atkins' IQ, which is 59. So Atkins was sentenced to death by the jury, but the Supreme Court ordered a second sentencing hearing because the trial court used a misleading verdict form. So during retrial, the psychologist testified the exact same thing, but the state argued that Atkins was only mildly mentally retarded, so he didn't qualify, so they sentenced him to death once again. The prosecution proved 2 factors under Virginia law: that A, Atkins was seen as a threat due to a string of previous violent crimes, and B, that his most recent crime was done in such a degrading manner, so they were concerned with how dangerous he could be. The state's witness countered the defense's argument by stating that Atkins' behavior, his vocabulary, general knowledge, all these things suggested that he did possess at least an average intelligence, so his sentence was upheld. So the ruling was a 6-3 decision in favor of the petitioner, and the Supreme Court held that executions of mentally retarded criminals is a violation of the Eighth Amendment, and it is considered cruel and unusual punishment. In a similar case, Penry versus Lina, the Supreme Court ruled that the execution of a mentally retarded person is not cruel, so this definitely affected the decision for Atkins versus Virginia, and the 2 cases are similar, but they vary in their outcomes. In Coker versus Georgia, the Supreme Court ruled that for someone who committed rape, sentencing them to death was an inappropriate form of punishment. And lastly, in Hall versus Florida, the court banned all executions of mentally challenged convicts, but they allowed the states to determine their own process to figure out who qualified for that exemption. So Atkins versus Virginia is significant because it could mean the beginning of the end of the death penalty, and an example would be Justice Sandra Day O'Connor, who stands firmly against anti-capital punishment. This case also affected the government in that each state has had to define mentally retarded for itself and determine its own implications, and it also influenced a verdict in hundreds of other death penalty